Okay, they told me that, oh wow. Yeah, turn it way down because I'll blow people out of here. They told me I had to turn this microphone on because they were recording it. And I said, okay. So I got to watch what I say. First of all, I want to say thank you so much. I want to say thank you to the Daynards for your wonderful contribution to allow me to be able to come back. And I told the dean, I told you this the other night, when I came into the building, I told her I didn't recognize a single wall. But within that half a day of being here, I did feel right at home, and it was really great to be able to talk to students and see some of the faculty that had taught me, and sitting down with Margaret and on that panel was extremely helpful. So I want to thank you, and can we just give them another hand, please? Thank you so much. And of course, when Steven Subrin walked into the room where I was, I really got down and kowtowed to him. And I said, oh, great one, oh, great one. So I want to start out by just making sure that I let you know what a special set of circumstances you guys are facing. I'm not talking about the loans that you have to pay back. I know that's a special set of circumstances. But I want to bring to you how important what you're going through right now is as far as students in law school. Let's do it by way of example. First year students, how many first year 1Ls in here? A lot of 1Ls. Okay, and so you haven't hit Thanksgiving dinner after your first year yet. This is how it's going to go. Uncle Josh. Everybody got that Uncle Josh? Okay? He's going to say, so you're in law school now, right? I got a question for you. And all of a sudden there's going to be this assumption that you've got this whole wealth of new knowledge that as a result of going to law school, people just can run things by you, that you're going to have this information that's going to make you someone that can answer all their questions. And it's going to be one of those convoluted contract questions, and you're going to say, I haven't taken contracts yet. And it happens. You're going to be with friends, and the people that used to talk to you and not listen to you at all, you're going to be like E.F. Hutton. You're going to turn around and say, well, really, that's not true. That police officer, and everybody's going to go. I tell you that because what you're going through is providing you with special knowledge. And with that special knowledge comes, I believe, a real earnest and real responsibility to realize that you're getting that special knowledge. You will learn things, you may not see it now, we talked about this in some of the first year civil pro classes. You will learn things that will connect the dots where people can't even think that have been in business for years. You'll learn how law interrelates with regard to even thinking about patent law in the chair that you're sitting in. You'll learn all those things, and that will be the special knowledge that you're going to draw on for the benefit of both your career and your clients. And I'm telling you that because you're entrusted with that. Because there are many people that take it and really don't do anything with it, and there are many people that take it and turn it into something that really makes change and makes effect in our community. So I'm encouraging you to think about how special it is. You may not think that you're special, but I think that you are, and you're special not only because you're Northeastern students, which I just happen to have an affinity for now, but because of the knowledge that you're going to get. With that knowledge does come the responsibility of understanding what you can do and what you can't do. Part of being in this practice of law, whether or not you're a litigator or you're involved in contract negotiations or whether or not you're doing corporate structure work or whether or not you're going to be just dealing with real estate transactions, how you conduct yourself, how you deal with the people that you're going to be dealing with, even though they may themselves not deal with you appropriately, is important. And I tell you that because there's something that I learned when I left here. I learned that it really made a difference on how I dealt with the judges and the lawyers and the other people that I dealt with, so that when I walk into a courtroom, it's kind of like doctors have a bedside manner. Well, the lawyers have a bar side manner. And you'll learn and from the very beginning that it will be very easy for you to be cantankerous, unresponsive, argumentative, and abusive, and you'll have the ability to do that through all the skills and information that come to you. And my suggestion to you is that that in and of itself does not enhance your reputation, nor does it enhance the reputation of lawyers generally. And I think while other people may have this cutthroat ideal of how lawyers are, we have the ability to change that. And I will tell you that when we do walk into courtrooms and from my office, immediately the word is, Brewington's office is in here. And that's important because the clerks will give you the opportunity to at least be recognized. But I'll tell you, anybody been into, how many of the professors or the practitioners have practiced criminal law, okay? Ever gone in and sat waiting for your case to be called and everybody else around you being bumped ahead of you? And you're looking like what, I didn't shower today? What's wrong with this? But those people that are in that courtroom have the ability to put the cases in a certain order to be called. They have the ability to recognize, and then it's supposed to be, in the order that you come in. It doesn't always work that way. It doesn't always work, and God forbid at some point that you really made an enemy in there. 2 o'clock, come back for the 2 o'clock call, counsel. That does happen. So it's important how your arguments are going to be received, whether or not you're standing on your feet or whether or not you are putting it on paper will have an effect on one. They're going to look and say, well, what office is this from? Anybody who's been working in a judge's chambers? Anybody in here done a co-op or worked in the judge's chambers yet? Well, I'll tell you, don't think that it's all the highfalutin scrolled stuff that goes on in chambers. There's a lot of talk about the lawyer and a lot of discussion about politics. There's a lot of discussion about, and I'll just tell you, very interesting to hear judges say, before they even read all the law, where do we want to end up on this one? What are judges coming with? They're coming with the role of saying, yeah, I'm going to be impartial, but they're coming with all the baggage that makes them human beings. They're coming with their own isms. They're coming with their own frailties. They're coming with all their politics, because in New York particularly, if you don't have a certain level of politics, you can't get elected. You don't get appointed. And in other places, that's true also. So you need to put that in all as part of your thought process in terms of how you're dealing with this, and how you're seen in that process is important. It's also important how you're seen in that process by your clients. And I will tell you that particularly with regard to the civil rights practice and even the criminal practice, but particularly the civil rights practice, a number of the people that we deal with, whether or not it's employment discrimination, Title VII work and other related statutes, or with regard to our police misconduct and police abuse cases, these are people who have been seriously impacted by the system. They have been disappointed, injured physically, psychologically, and they have become in a lot of different ways jaded about what justice is and can be, because they have been the victims of injustice. And I will tell you that it plays on your mind sometimes to hear some of the stories that that come into your office when you're a civil rights attorney. I see Howard here, and one of the things that we see many times is that people getting beat down for no good reason and then subjected to other types of psychological warfare by people wearing blue. And that's not to say that all police officers are bad. They are not. As a matter of fact, we represent a good number of police officers, and it's interesting, the ones that come back to us sometimes are some of the people we litigated against in the past because they knew that we were trying to do the right thing. But in these situations, particularly with regard to some of the discrimination cases and the 1983 police misconduct cases, we have people that are seriously impacted by the system. They have been called names, they have had pay taken away from them. They've had demotions for no good reason. They have been falsely arrested. They have been beaten. They have been spit on. They have been cursed at. They have been name called. And all by people that supposedly were supposed to be people that should be upholding their rights rather than tearing down their rights. What do you think their view is when they come into a lawyer's office and you start talking about all the legalese that you can, because we will have all that lingo down, by the way. It says, well, it appears that your Fourth Amendment right has been violated, and as a result of that, we should really talk a little bit about how that fits into the evaluation under your Section 1983, and if these people are not state actors, should we really look at this as, and after a while, they're going like, do you feel my pain? Do you understand what I went through? This man beat me in front of my kids, and I couldn't do anything about it. And it makes you stop. It makes you realize that when these people are coming into your office or coming in for that first interview, that while you may have your own personal problems, for that time period, they're looking to you to be able to, one, a lot of times unload and tell somebody their story, but two, to have someone say, I understand what you're telling me and I feel real bad about what happened to you. Either way, whether or not you're going to take the case or not. The responsibility in that situation is to not dehumanize them in a way where the system continues to make them into an object and make them rather into a person. To realize that these two young men, the little Rivera brothers, we call them, because they're both about this short, they went to a concert, Pearl Jam, is that the name of the concert in Madison Square Garden? And they got in there, and some dude in there who was like big as a house, didn't like the fact that one of the little Rivera brothers said, could you sit down, please? I can't see. And the guy turned around and smacked him in the face, and he pushed him back, and they all got kicked out of the concert. And the Rivera brothers went looking for a police officer because they wanted to make a complaint. And they went to one set of, this way in New York City, all types of police forces: Metropolitan Transit Police, the police that deal with both New York and New Jersey, and the police in Penn Station, and New York City police. 4 police departments available. They went to 2 of them, and they said, not us, go to them. Not us, go to them. Nobody would take a complaint. So finally they walk into the police station, which is right in Penn Station, New York, and they say, we want to file a complaint. And they said, get out of here. Come on, what are you? And they said, no, somebody beat us up in Madison Square Garden. We want to make a complaint. Would you take a complaint from us? And the response to them was, get out of here. You got your behind beat over in Madison Square Garden, and now you want to cry about it? Get out of here. You say, well, why would they even do that? Well, the reality is that they just didn't take them seriously. And that's not unusual for a number of situations to happen. So what they did was, the Rivera brothers said, well, fine. They huffed out. They said they slammed the door. I said, did you? They said, yep, I slammed the door, and I huffed out. Well, one of the officers didn't like that. So he put on his stuff, and he walked out, and he confronted the Rivera brothers right in the middle of Penn Station, right underneath the cameras, which, by the way, they can't find the video of anymore. That's okay. And went to the Rivera brothers and started provoking them. Did the chest bump thing? Yeah, it's a great thing. I just love it. It's just like, so you didn't like what we said to you, huh? Why'd you slam the door? And Rivera brothers, and as soon as the Rivera brothers did one of these, he said, what, you're touching me? All right, that's it, you're under arrest. One ends up with a fractured nose. The other ends up with a fractured set of ribs and TMJ, temporal mandible joint disorder. And they both get arrested, charged with the normal, obstructing governmental administration, resisting arrest, and disorderly conduct, for wanting to make a complaint. Those are the normal 3 that we get in New York. They kind of like go together. And the Rivera brothers have to go through this entire process. They're not taken to a hospital. They ask to go to a hospital. They're not taken to the hospital. They finally get turned over from the police that are at Penn Station to the police for another precinct. And the police from another precinct say to them, "You guys should really file a report about this." And they said, "That's what we've been trying to do." And they said, "Yeah, because those guys are notorious for beating people's behinds." And so what they did was they had to go through the entire process. They had to go 6, 7 months till the charges got dismissed, and they pursued the case. But all along, all they wanted somebody to do was take a complaint. We sat down and talked to them, and they said, "You're the first one that ever delved into any of the facts and how I felt. The cop, when he picked me up by the scruff of my shirt and ripped my shirt." And I said, "Really?" Of course, I'm saying, that means that there's going to be proof of that if they took the mugshot picture. And sure enough, it was. And his face was bruised in the mugshot picture. And they claimed that it was self-inflicted, that after they put him in the cell, that they did that to themselves. And I said, yeah, okay, whatever. But the Rivera brothers, fairly well educated. One's a teacher. One's does financial investment. Went to this Pearl Jam. They wanted to have a good time. They got punched out. It was not a good situation, but they wanted to make a complaint. But the biggest thing for them was nobody would listen. Nobody would receive their pain to the point where they could really just tell it. And I'm telling you that because you never know who's going to walk into your office, who's going to come before you, who that victim is that's going to be before you, whether or not if you're working in the DA's office even, and how you deal with them, because it's not all one-sided. But people really make a difference on what and how we do things and how we interact with them. Let me introduce you to a couple of people. I want to introduce you to John Mims. If this thing works. Yeah, there we go. John Mims. He was a African-American man who had a drug habit, who was out, not necessarily doing any crime, in Southold, New York. Anybody know the eastern end of Long Island? Okay, Carl does. Well, he was out there, and there's a Southold police officer that was a legend. He was known to be a real K.A. guy. He would kick people's behinds. That was his reputation. And he knew John Mims. And John Mims was driving a vehicle that was not his. He had borrowed it from one of his friends, who was one of his people that he used to get high with. And he was driving it, and he was on the side road. Well, this officer saw John Mims, pulled him over, and claimed that when he pulled John over, John was weaving all over the road and doing this, but he just happened to know it was John, and he was trying to see if he could shake him down for a drug bust. The officer said that he told John Mims to stop. John said, "That's true." And then he said that he told John Mims to stick both of his arms outside the window of his car. And John says, "That's not true. He told me to get out of the car and put my hands on top of the hood, and then the next thing I remember was getting hit in the head with a flashlight 6 times at least." And what you don't see here is, maybe you can see it a little bit here, John Mims' skull had ruts in it from the mag light that had hit his skull multiple times. And at this time, he was blacking out at the time that this was taken in the police station. This is their mugshot. This is not us. This is their mugshot. And he says, and at the time that he hit me in the head, my hands were there, up there, and then he cuffed my hands, and then he hit me some more and called me everything except for a child of God. And I said, okay, that's fine. The police officer insisted, said, no, this is what happened. I had Mr. Mims stick his hands out of the window. He stuck his hands out of the window. I got one cuff on, and then he got belligerent, and I held on to the other cuff, and he got out, and we got into a tussle. He punched at me, and I had to defend myself. That was, a plausible story. Yeah, right. except for the car was a 87 Cavalier or whatever it was. And after we heard the story over and over, I said, let me go look at that car. Real careful. And it turns out that it's not a convertible, and it has the door frame that goes all the way around. So I hammered him big time. So you held onto that cuff, right? He said, yes, because a swinging cuff could be a weapon in and of itself. Oh, of course it could, officer. And so therefore, that's why you held onto that cuff, and you had to defend yourself with your right hand. Absolutely. I said, okay. So he never let go of the cuff. We went, Professor Rowan, and got a 1987 Cavalier door out of a junkyard and brought it into the courtroom and put it on a set of wheels and set it in. And I said, Your Honor, I want to call the officer first on my case. And he says, oh, okay. I said, officer, I want you to sit here. I said, well, I'm going to be Mr. Mims. You said that you cuffed. I said, no, cuff my hand. I had a set of cuffs, cuffed my hand. And I said, and you said that you held onto the cuff. That's right. And he said, Mr. Mims got belligerent and got out and you held onto the cuff. That's right. And he said, I said, okay, how'd he do that? How'd you do that? He said, and the jury's going like, and finally, Mr. Mims, who was sitting there, if he could have skipped in his chair, he would. He would have just, it was for him one of those, and you don't get many of those aha moments, but it was like, aha. But for him, it made a difference that finally something that wasn't just his word against the other person, the police officer's word, started to come to light. And all of a sudden, instead of just looking at this officer who came in with all his braids and everything on the stand, everybody's in the jury is looking at him going like, what's up with that? What are you talking about? And then it just went downhill from there. This case, Mr. Mims did fairly well. The jury awarded him for his injuries and punitive damages somewhere around $400,000, which was not a lot of money, but the jury, that was a Suffolk County federal jury, and they did. And we did our attorney's fees application, and we did well as well. But for Mr. Mims, everybody was just thinking about him, about this. And by the way, the criminal charges we got dismissed as well against him. But they were thinking about this guy who was a druggie, had a drug habit, a bad background, everything, and he just got his butt beat. But he really needed somebody to stand in the tide for him and push back. And John Mims had problems after this. He had problems blacking out, which he didn't have before. He had problems every time he saw someone in a uniform to do. He would see a uniform, and this was his reaction. He would just, that would be his flashback. He would see a uniform and he would snap like this. I said, Johnny, you all right? He said, and he had a stutter. He said, yeah, Mr. Brewington, everything's fine. But he's damaged goods. Yeah, he had his own life problems before, but after this event, John Mims was never the same. Let me introduce you to a couple more people, or at least one more person, right now. Well, in Suffolk County, we had a situation where two Mexican day laborers were attacked by two skinheads, and this was the setup. The setup was that they went and got them to do day labor work, got them in their car, took them to Dunkin' Donuts to get breakfast, and then said, we want you to go to this secluded place out in Suffolk County, right near the Long Island Expressway, and do some work for us. What we want you to do is to go into this area where it's covered, it's an old, secluded place, and we want you to move this pile of stuff, shovel it, and move it over here. And we'll pay you X number of dollars for the day. And our guys, two of them, Israel Perez and Mr. Izquierdo, said, okay. They got in the car, and they went to this place, and they're working with the shovels, and they're like talking, why are we doing this? Why are we moving the wood? What's the purpose here? Well, lo and behold, these two individuals, Mr. Slavin and I've forgotten the other gentleman's name, had been part of discussions online with the Posse Comitatus, World Church of the Creator, and a couple of other hate groups about killing Mexicans. And what they indicated they really wanted to do was they wanted to lure these people there because they were going to kill some Mexicans. That's how much their hatred led them to this crime. This is Mr. Perez's head, and you're going to see his injuries in a second, but Mr. Perez and Mr. Izquierdo were doing the work. Mr. Slavin and the other gentleman came in with a post hole digger. Anybody ever done that? Where you do this and you dump dig a post hole, or with a Bowie knife, big hunting knife, and a pickaxe, and started to swing and hit both of these gentlemen with the pickaxe, the post hole digger, and swiping at them with the Bowie knife. The Bowie knife actually connected only once, because that's probably the most deadly in terms of having a small puncture wound that could go through major bone, except for the pickaxe did land. And the first blow was to Mr. Perez's head, and that was with the post hole digger. Hit him on the side of the head, and he began to bleed just like someone in a slaughterhouse. And then they hit Mr. Izquierdo with the pickaxe and with the post hole digger, and he was knocked unconscious. Mr. Perez was left to fight alone against both of these guys, and he said, I just went wild. I just went crazy. I just started doing everything. I tried to take stuff from them, and after a while, I knocked them both down, and I grabbed Mr. Izquierdo, who had started to come to consciousness, and I ran him, and we ran through the woods. And you can see the trail of blood going through the woods, and they ran onto the Long Island Expressway and stood and tried to stop traffic, and nobody would stop, except for the person that did stop. And just goes to show how good things do happen to good people. The person that stopped was an EMS worker coming from New York City who lived in Suffolk County and saw that these men looked like they were in distress, and he pulled over, and he immediately started giving aid to try and stop the bleeding. And these people, then the police came. The police came and didn't really believe their story. They started dealing with her. So they said, let me see your working papers. And that was the big issue with the Suffolk police. But eventually they finally got the story that these two men had been lured to this place, secluded place, to be seriously attacked. And these two men were eventually arrested, Mr. Slavin and his colleague, for federal civil rights violations, because the local district attorney really didn't want to touch it. And that's unfortunate because of the jurisdiction that they were in, that it was unpopular to try and defend these two day laborers who were Mexican immigrants. Mr. Perez told the story of how he had to put his hand up and his arm up, and you can see his arm is very swollen here, to stop the pickaxe and the post hole digger from multiple hits. And his arm was just fractured and broken and lacerated here. He had gotten, this is one of the places where the knife swiped his face, and he ended up getting 6 stitches there in his head. There were some 104 stitches in his head. And he just told the story about how he just kept thinking, I've got to live to be able to tell somebody this. I've got to live to be able to tell somebody this. The pickaxe punctured here, missed the clavicle bone, missed the main artery that runs up and down the neck, and went through only flesh, right through the trapezoid muscle up here, and was very lucky. But that was the bleeder. That was the bleeder that bled all over the place and led the trail of blood there. But for a period, and it's interesting, it was a story, it was all the news, it actually went national for a while. The 2 guys that dealt with these individuals did go to jail. But we felt that it was important for us to take the case on from a civil standpoint. Even though we knew and made the decision that we probably would never see a dime or a dollar out of this, but it was important for people to understand that if indeed you were going to treat people this way, that you were going to have to pay a couple of ways. One, time, But two, these gentlemen are going to have a judgment against you and they're going to track you down no matter where you are and take whatever money you can make for doing what you did. And we took the case. We got a $1.7 million verdict from a jury on the damages trial alone, because those of you who may know, everybody knows res judicata and collateral estoppel, res judicata, because of the criminal violation of the civil right. We were able to apply that and then move for summary judgment against these two individuals on liability. But these individuals, nobody else wanted to deal with the civil case because there was really no money there. And the reality was, that's right. But we made a decision to give them the opportunity to be able to say, you've taken something from me and you do owe me something. Because that's what our system allows. The decision to do that was not one that was easily made, because we knew the investment of time and effort going into it was not going to reap any benefit. But we made the decision anyhow, and it made a difference to these young men who decided, even though that they were at stake in terms of a lot of different ways to come forward. And you never know when people like you are going to come to you and need your involvement in their lives to try and make a difference, so they can at least get some closure to it. These individuals were not deserving of what they experienced, and I don't think any of the victims of any of the discrimination that does take place still in our country or even in our legal system do. But you should really be cognizant that in this entire process, while you're taking on this responsibility of being caring and understanding of these people that are bruised and battered and injured, that you're in the mix too. And I wanted to come to you from a real standpoint to let you know that it can weigh heavily on you as an individual, because you've got to be able to understand that while you're caring for these people, you must care for yourselves as well. And that's important for you to keep in mind, because I will tell you that it is very easy, particularly as lawyers with conscience, to pour everything that you have into that and for you to get drained to the point where you're not an effective advocate. So you've got to give yourself the ability. I'm not saying don't be uncaring. I mean, you should be caring. But I'm suggesting what you need to do is make sure that in the process that you are understanding that you have to give yourself the opportunity to recoil, the opportunity to respond, the opportunity to give yourself the opportunity to heal, because I will tell you, this stuff will wear on you over and over again to the point where you get worn down like the end of a pencil eraser, and then you can't erase anything anymore. You're done. And you'll also have clients, and we know this, who come to you and they're good at working everything that they come in contact with. The system, their employers, you, and they're used to doing that because that's how they maneuver through the process. And you've got to cut through some of that, because at some point, even though they may be an injured party, you also have to deal with the fact that they may very well be working you and working the system, and you have to be careful not to be so sucked into that you become a disingenuous advocate for a disingenuous client who has some isms that are not all of the making of someone else. That's a tough balance to keep. And I'm encouraging you to think about that, because I think many of the people in this room, if not all, want to go out and do some real good for changing things that are going on. But in the meantime, you have to be careful that you don't become a casualty. Because I've seen too many good lawyers do that. Or to be driven into a situation where, because this really needs to get done, you do something which is just stupid in terms of your practice and your license. And that temptation does come. It's there. 2 o'clock in the morning, you're trying to figure out, do I backdate this document or not? That happens. And I'm telling you that the investment that you're making in yourself, and for everyone that's put you here and lay the groundwork for you to get here, it's not worth it to put yourself at risk, nor is it worth it in this situation to be in a situation where you put the investment that you put in to your education at risk. Let me introduce you to the last person I want to introduce you to. This is Alvenia Toombs. Nice picture, right? Attractive young lady, right? This is her high school picture. She had gotten this haircut. It was sharp. Everybody, she was walking down the hallway going, everybody saying, nice haircut, Alvina. She said, taking my picture today. And she took this picture, very happy, bright eyes, you know, middle of the road student, but very popular. One summer in early 2002, 2003, Alvinia is out in the neighborhood in Roosevelt, New York, hanging out with folks at the neighborhood bodega, bar, store, and they are sitting out there doing what? They're hanging out. She's 18 years old, they're 19, some of them 20, all of them not drinking age, but they're hanging out, and they're drinking, and she says, and I said, Alvinia, what did you do? She said, well, I was hanging out, and I bought this beer. I said, what kind of beer was it? She said, a St. Ives. Yeah, St. Ives? Okay, well, whatever. I don't drink, so, you know, yeah. And she said, and I took some sips of it, and then what'd you do? I said, well, we all got together, and we got in the car, and we went to Jamaica. She's in Long Island, in Nassau County. They went into Queens. And so what were we going to do? We were going to go to a club. Now, some of the folks in this room, the ladies in particular, she had on one of those summer dresses that had about that much material, had no pockets. It was, it was not a lot of dress, okay? She said, and I went, and I said, what did you do? We all went in a van, and we had a cooler, and what was in the cooler? The cooler had soda and fruit punch in it. And I said, what did you have? I had the beer, and I had it on the floor, and I took a couple more sips. And I said, then when you got to Jamaica, what did you do? We all got out of the van, and we decided that we were going to go into the club. And I said, what did you do? I poured the beer out in the parking lot. I said, why'd you do that? She said, Mr. Brewington, it was nasty. And I said, okay, cool. And I said, then what did you do? She said, I took a step, and then a car pulled up. I said, what kind of car? She said, it was definitely a DT car, a detective car. And I said, oh, okay. And she said, what out? And then she said, then a guy got out in uniform, and he said to me, it's not going to be that easy, young lady. And she said, what do you mean? He said, tell me your name. And she said, Alvinia. And she spelled it for him, Alivania. And he said, okay, and he wrote it down on a little scrap of brown paper, and she was watching him write it down, and he spelled it wrong. And she said, no, there's an I there. And he said, and he wrote it down again. And she said, no, you spelled it wrong again. There's an I there. And he said, that's it. You're a pain in my ass. You're going to jail. She was shocked. Everyone else that was around her was shocked. And she said, what am I going to jail for? And then she had the nerve to say, my stepfather's on the job. In other words, he was a police officer. And that infuriated him. He said, I don't care who your effing stepfather is. And he said, put your hands behind your back. He cuffed her and then pushed her into the back seat of the police car. He was in the passenger seat when he got out, and in the driver's seat was his lieutenant. And this officer's name was Brooks, by the way. I like naming him because he needs to be outed. Brooks put her in the back seat. All of her friends are saying, what are you doing? We'll tell you whatever you want. Here's a background. Well, no, she doesn't have any ID on her, which was true. She didn't have any ID on her. Her friends were carrying her ID. And they said, here's our ID, and here's her date of birth, and I know her date of birth for sure, and it's true because it's the same as mine, and blah, blah, blah. They told him, shut up or you're going to go to jail too. And Officer Brooks got into the back seat of the police car while his lieutenant started to drive. And he put on leather gloves in the middle of July. And he began, with Alvinia's Tombs handcuffed behind her hands behind her, to smack her in her face over and over and over again. And in her face, and she just kept going back and forth. And she yelled to the lieutenant up front, tell him to stop. I'll do anything. I'll tell him to stop. And the lieutenant leaned over and said, "Yo, man, chill." And Officer Brooks didn't chill. He continued to smack her and use words such as, "You little whore. You little black bitch. I bet your mother doesn't know you're out here doing what you're doing." And he referred to her using every derogatory name that you could think about. And then he took her face, and this is what Alvinia said. He grabbed my face like a basketball and he smushed it, her words, up against the back window that curves around in the back. And she felt her face pushed up against that. And I said, "Alvinia, what did you do at that time?" Again, asking her story, because no one had really asked her about it. And she said, "Mr. Brewington, I'm going to tell you the truth. I bit his thumb as hard as I could, and I didn't let go." I said, "Good for you, girl." And she bit, and she wasn't let go, and he called her a bitch and called her everything else. And then he, with his spare hand, he started punching her in the face. Boom, boom, over and over again. And she finally let go. She put her head between her legs, and she pleaded for her life. She said, "Please don't hit me anymore. Please don't kill me. Please don't hit me. I'll do whatever you ask me to do." Well, they drove to the precinct right in Jamaica. And the lieutenant, who obviously could see what was going on, even though I said, "Well, sir, couldn't you see what was going on even if you looked in the rearview mirror?" He said, "No." So, we brought into the courtroom, right, a rearview mirror, and we set it up. I said, "Oh, yeah, really?" He said, "Oh, well, I might have seen a little something, but I thought it was just her flailing her arms." I said, "Well, her arms were handcuffed, weren't they?" "Yeah, well, she was flailing her legs." I said, "Oh, you saw her legs." Okay. But, this is just how ridiculous sometimes it gets. But this was in the criminal trial, by the way, because she was charged with felony assault of a police officer. The felony was biting his thumb. No marks, no treatment for it, but a felony assault. That's what she was first charged with. So, takes her to the precinct. The lieutenant gets out, goes in, leaves Alvinia with the gentleman that was just smacking the crap out of her. He reaches into the car, grabs her by her haircut, pulls her out of the car, and takes her face with her handcuffs behind her and smashes her twice into the concrete, forcing her teeth through her top lip, fracturing her nose, deviated septum, puffing under her eyes, blood all over the place, referring to her using other derogatory names, which I don't care to repeat at this point. Then he took her in, and rather than put her in the cell, handcuffed her next to the garbage cans. And we know this because her friends had followed her to the precinct and actually had gone around the back and peeked in a window and seen her where she was handcuffed. And she was just crying, just saying, "What did I do? What did I do? What did I do?" Well, we went to court. Anybody want to guess how many times we went to criminal court on this? Take a guess. Guess it. Try 32 appearances. 32 appearances before we got to a trial. It started out as a felony, assault 2. We had hearings. After the hearings, the DA lowered it to a misdemeanor assault, 3rd degree. After that, we said, ready for trial. We answered ready for trial for so many times I got tired of saying it. And after we answered ready for trial, they lowered it again from an A misdemeanor to a B misdemeanor. Anybody want to guess why? Now, we're talking from a felony to the lowest level of misdemeanor in New York State. Because they didn't want to have the trial go to a jury. They figured they were going to take their luck with a judge because a B misdemeanor, you're not entitled to a jury trial. With an A misdemeanor and above, you are. So we pulled a good judge. We tried the case. The judge wrote a 7-page opinion on a B misdemeanor case, saying she'd never seen police officers lie like they had lied on the stand. And we got all the charges dismissed. But Alvinia Toombs had been subjected to an ordeal that no one should have been subjected to. And when she walked into your office, her story seemed almost unbelievable until we asked them for her mugshot. And this was the Alvenia Tombs that was that night. And if you look, you see her hair's grown out a little bit more. But we couldn't make the angle any better, right? Fracture in the nose, split nose, puffy eyes, dead eyes, lip going through. This is a woman that needed care. She was a young lady that didn't have a lot of world behind her, but came to us really looking for someone to really just stand up for her and not back off. We took a lot of time with her because she was really affected. When I say really affected, she would pee her pants every time she heard a siren or saw a police officer, and she had police officers in her family. She got psychological treatment and was told she would never, ever, ever be the same. She had problems at that point with regard to her family because the family kept wanting to blame her and said for somehow it was her fault for doing that. She had problems with her friends because her friends kept saying, well, why don't you just leave it alone? You know, they're only going to follow you around and bust your chops if you keep following this up. And she just said, I have to deal with this. And it was not easy for her, as it is not easy with many of the people that we come in contact with. That being people that are really coming to us to really just say, help me. So when I tell you it's an awesome responsibility, it really is. I ask you to care for yourself, but I also ask you to remember the people that we have to care for as lawyers, because that special education, that special knowledge forced us to negotiate all types of stuff just so that this, with regard to Officer, we forced him to retire. And we couldn't get him fired because they wouldn't fire him. So we turned the heat up as high as we could. And all of a sudden, during the middle of the criminal trial, he put in his retirement papers. I was happy. I said, get out of here. But for Alvenia Tombs, it's not going to take it away. That's what our system allows. It's an imperfect system, but it's our job. I'm not just saying mine. It's our job to take that system and work it like the best we can for the clients that we're working for. Because people like Alvenia Tombs really depend on us, are really relying on us to be the special types of lawyers that are going to change the whole view of why and how lawyers do what they do. And I'll just tell you, we did well for Alvenia. The case settled, I use this term, to the mutual satisfaction of the parties. But it could never be satisfying to Alvenia because she's never going to be the same. And I come to you to talk to you about this today because there are different aspects of what you do as lawyers, and some of you will never see the inside of a courtroom, some of you won't be litigating 1983, but when you start dealing with those people who had their homes taken from them in mortgage foreclosure or treated improperly in terms of contract, or dealing with things where they've just been abused on their job, or they just can't take it anymore the way that they're treated or talked to, listen to them. Give them the opportunity to at least tell the story. And if you can't help them, be honest with them. Because the worst thing that you could do, is pump them up with false hope. Because instead of being here and falling, they're here. And when they fall from here, it's a much longer fall from here. They're relying on you. And I just want to say thank you for being willing to do the work that you want to do and the work that you're going to do, because I'm telling you, you're needed out there. You're needed out there. There are a lot of lawyers. There's not a lot of good lawyers like the people that are going to be in this room that you're going to be. So I just thank you so much and ask you to continue to do the work that you're doing. Thank you so much.
Fred.
Thank you.
We have a few minutes if people have some questions they would like to pose.
It happened while I was here at Northeastern. I'd been involved in a lot of activities where I was advocating different positions, student government stuff. Thanks, Dan. Here as well as in college. I've got to really give the credit for deciding to do civil rights litigation to Denise Carter-Bonilla, who she was a former professor here, and you may have heard about Denise here. There were a group of folks that used to call Denise's kids, and Denise really served as a catalyst for challenging a lot of us to just say, so what are you going to really do with this? You're going to work for a corporation? You've got a good job in a corporation. You really want to do that? You know there's people that need you. And I'd say, Denise, come on, give me a break. And she would ask the tough questions and push and push. And in one discussion that we had, it just went off. I just said, yeah, I really want to do this. And she opened up civil rights and constitutional law to me in my second, third year. So that's really what made me when I had the fire in my belly to do that type of work. I knew I wanted to do some type of public interest work, but the litigation opened up when I really started getting involved in the Bakke decision and listening to her discussion on that. She was excellent. We used to love to see her on television to debate somebody because we were going to say, okay, get the Band-Aids out because she's going to cut somebody. Right? But that's how. Yeah. Any other questions? Yes. It is difficult in terms of first understanding where lines can be drawn. Your job as an advocate, and also because you are considered that expert, is to understand what the law will allow. Your client comes in, they may want certain things, and for instance, I come into a case and the client says, I'm not settling unless I get $6 million. And it's my job to say, I know that's what you want, it's not happening. This case, your case, in what is going to be allowed in our system, what's allowed under Title VII in terms of the dollar amounts and limits and ceilings that are there, what may happen in your case with regard to the lack of treatment that you have in terms of psychological injuries, it's not a $6 million case. And I've got to tell you that. Now, I can't put a value on it now, but if you're expecting that you're going to draw the line at $6 million, I can't help you. And I'm not going to take you into that false charge, tilted that windmill, and still, end up where I'm going to be disappointing you. You'll never be satisfied with what I do, and that's not going to be something that's realistic. And in those situations, you're better off telling people actually what they should expect and can expect, as opposed to what they want to do. Legal decisions should be your decision. Now, if there are choices as to what legal decisions should be made, you should lay it before the client, and that should be a shared responsibility. And final decisions, obviously, as long as it's not going to be contrary to your morals as an attorney or your responsibility as an attorney, is something that you can share with the client. But you've got to draw that line, because many times clients will say, no, I don't want to do that. Why do we have to give them that document? Because the rules say so, and if we don't give them that document, later on when you raise it and you want to go, aha, all of a sudden somebody's going to roll their pants up real hard and kick you where the sun doesn't shine, and your case is done. That's why. And if you don't tell them that, for instance, I had one gentleman was suing Coca-Cola. Every time I talk to him, he's going like, I got a document on that. And I want to reach back and say, I'm going to cut you, Manny. Because you can't do that. And we're now at a point now we're getting ready to do summary judgment motions, and he's saying, well, maybe I got something at home that might help us on that. And I'm saying, it's too late. I don't care what you got, because I'm not putting it in. It can't go in, because that will only impact and affect our ability to try and answer the question, why didn't you give it at the time that requests were made for all the documents that was, and this is a document which is responsive to one of those requests. So you've got to then tell the client what the rules are. They don't know the rules, just like when you prepare them for a testimony. You can't tell them, they can jump up and down and then cuss the judge out when the judge does something wrong. I do now. The answer is, I met yesterday with career development and co-op folks, and the answer is I'd never gotten a resume from anyone from Northeastern. We have 3 paid civil rights interns that my wife and I set up for the whole summer, and I'd never gotten a resume. I got resumes from Southern and Harvard and Penn and Pitt and Howard and Hofstra and other places, but never got one. But that's going to change. And so the answer is yeah, and we're going to try and figure out a way where we can do co-op stuff. That's really, the co-op is not in our budget. We're not a big office. There's only 8 of us, but we're going to try and figure out a way to make that happen because I think it should. Yeah. Yes.
You talked about the idea of self-care.
If you ask everybody else, they'll say no, because I put a lot of time in, and so do the lawyers that work in the office. But there are things that I make sure, my involvement in the church, my church activities. I have a gospel group that travels around with folks, and that's an activity for me, but it's also an important part of who I am. I coach high school football. I've been doing that for 28 years, and that's time that's set aside for that. My wife has forced me to take vacations, which I'm not good about vacations. I got to be honest. I'm not good about the relaxing thing. So while she relaxes, I go climb a tree. It's important to try and find that balance for self-care, but also the psychological stuff while you're in the fight. So you've got to step back and become marginal to some degree to look at it and give yourself an evaluation of what am I doing, how am I doing it, and how is this looking overall from the outside? Because a lot of times you're in the fray, and as you're in the fray, you see stuff coming at you, but you never see the stuff being thrown. Mm-hmm. Mm-hmm. Well, I consider that civil rights work. I mean, the answer is it has, we've all been wrestling with issues of qualified immunity and when and how that does apply and how broad is it going to be and can we help narrow that. We've done evaluations with regard to the limitations and almost the complete invasion of Monell claims with regard to the actual municipal liabilities and responsibilities has gotten very difficult. So I would say, yeah, it's gotten more difficult, but it requires us to be as thrifty in dealing with approaches as the other side that's trying to close us down is in doing so. And that does require some thought, and it also requires us to understand those components that are making it more difficult better than folks that we're opposing. Because a lot of times the people that we're opposing, and particularly I'm seeing more and more of my stuff being farmed out to private firms by municipalities, because the rigor with which we go after stuff, we're making them put a lot of hours in. But a lot of those private firms don't know the 1983 practice. They're big firms or they're firms that are politically connected. So oftentimes you're in a better situation to drive the discussion, at least as it's going into the court. But it is more difficult. I'm sorry, Section 1942, United States Code, Section 1983, is one of the remnants of the Civil Rights Act of 1866, and it serves as an opportunity for individuals who have been wronged in terms of their rights, either by statute or constitutional rights, by a state actor or a municipality or a municipal actor to sue for those violations. And it is a good way to try and pull them into an environment where they may be uncomfortable, particularly federal court, because a lot of those entities will be very comfortable in their state courts, although we don't only sue in the federal court, but in their state courts where you have a lot of political cronyism going on, even though that's not all true in the federal court either. But you'll have a better chance many times there. The judges are sometimes the judges are sometimes a little bit more used to dealing with those issues than the state court judges are. But Section 1983 litigation, and I still believe that Section 1983 litigation is a cutting edge area that we haven't yet still started to open up the door on where we can go with it. We just need folks like you to come up with new ideas. Well, the reality is that sometimes you've got to pick and choose those things that you're going to do because of the limitations on you, both as a lawyer and understanding that your roles can't be too blurred. As an advocate for your clients, sometimes you can utilize that litigation as a vehicle for change, and I'll give you a prime example in a second. But you've got to be real careful that you don't start to become identified as the client. And you lose yourself and you start to identify so much with the client's plight that you lose your ability and your objectivity with regard to your ability to advocate effectively for the client. And it's a very fine line. Let me give you one example. We have a young woman, Joanna Bird, that was killed by her boyfriend very recently on Long Island. He had orders of protection against him, several. Police did not follow up on the orders of protection. He said, I'm going to kill her. Everybody laughed and blew it off. 2 days after the police let him go, they shouldn't have let him go. They had him. He went and killed her horribly. He abused this woman. He tortured her in the front vestibule of her own apartment. And police still laughed about it like it was a joke. Well, in that situation, we took it on as a social issue for women generally, but also women in that African American community who we thought were being treated the same way. For instance, they'd play the game. They'd go, now, honey, if you really want us to arrest him and he wants to bring charges against you, we may have to arrest you too. You sure you want to bring charges? The game was being played over and over again. And then the police would then write in their blotter or in their memo book, a domestic dispute, unfounded, no basis, withdrawn. You know, the game was being played. So in that case, we pushed with regard to this, and we're in the middle of that litigation, but one of the things we were able to do was force the Nassau County Police Department, Nassau County, right? You think it wasn't Nassau County, it was. We found that they did an internal affairs investigation because they had the wherewithal to do it. They found that this had happened not only to Joanna Bird, but on the calls just before her and the calls just after her. The officers were doing the same thing in the same community, largely African American women who were calling for this type of help, and they did nothing, didn't properly document it. And we are now in the process of dealing with that as a Monell claim, which is Monell versus New York City Health and Hospitals, Department of Social Services Corporation. In that claim that we're dealing with, we now have, through their own documentation, a pattern and practice. And the first thing that we're doing is we said, would you like to sit and talk about this? Because the reason we want to do that is because we can do more in settlement than we can do in a verdict. Because the verdict may be very limited with regard to what the dollar amounts are and what the court may order. But in settlement, we could talk all about training and responsibility and doing this. And if they're willing to go for it as part of the settlement, we get it in the form of a decree, or we can actually get it in order where it becomes stronger. So that's one way of doing it. But you've got to be looking for those opportunities. You've got to be open to understanding what your role is in this situation. My first role in that case are the 2 kids that she left behind. That's where I'm going first. They're going to be taken care of. They're going to get a chance to go to private school. They're going to have a chance to do whatever they want to do and grow up in life, because they're not going to have their father, who is the boyfriend of one of the kids, by the way, who's going to be in jail for life where he deserves to be, in my opinion. And 2, they're never going to have their mother. And grandma who has the kids right now, just doesn't have the wherewithal to give them, and this was a young woman, her daughter, who was working 2-3 jobs, taking the corrections officer test, wanted to do something, was really just trying to get up and out, and not going to be there for those kids. So our first responsibility, and Valerie Cartwright, who's the associate, some of you may know her from the American Bar Association. She was the head of the Young Lawyers Division, works in my office. She's my associate who was assigned to this case with me. We're going to take care of those kids. We're going to take care of them. I don't care what happens. It could rain, sunshine. I don't care. Those kids are going to get what they deserve. I'm not passionate about this stuff. Mm-hmm.
A lot of community groups are.
That the one that was in the subway?
Yes.
Yes, okay.
Yeah.
I think there is a responsibility there to play a role in a couple of ways. One, to be a good sounding board and advisor. We deal with a lot of community organizations, and we pull people together to try and talk through the problems and take a look at what some of the issues are and what some of the legal ramifications of actions are. A lot of times people want to go out and they want to do some stuff that's not going to be helpful in the long run. You can't prevent them from doing that, but you can try and provide good information. From a leadership standpoint, once you are seen as being a credible source of information, there may be opposition that comes up against it, but you can do the best that you can to provide folks with guidance. You can't make people do certain things, but I know that what we try and do is, for instance, we're getting ready to go after, anybody here from Long Beach, New York? Long Beach, New York? We're getting ready to go after the city of Long Beach big time because I didn't want all my stuff getting out. But because of how they've been treating African Americans who have stepped up and opposed them politically. And the fact that they've stepped up and said, you're not good for my community, I'm not supporting you anymore. Those people that work for the city are getting slammed over and over again. So we've pulled together people in the community, the pastors and everybody else, to try and put together a unified front. So even probably yesterday was Tuesday, I'm sure they went to the city council and made everybody very uncomfortable and made a record for the newspapers to start to write. So we start getting issues in front of the public about what this community is saying, and it's just not a lawyer crying in the dark. Well, you've got to understand all the rules first. And I say that because it's really important. You can't take a criminal case on a contingency basis. Can't do it. Shouldn't do it. Don't think about it. It's not happening. But we charged Alvinia for her criminal trial. We just deferred her payment. And we gave her a bill. And we deferred her payment till we got to the civil case. And we made it very clear that we were not acting pro bono because that was a special damage of hers in the civil case. In a case like that, you do have to make some decisions. You've got to make some of it is, there's risk in almost everything that you do. And some decisions have to be made based on the possibility of what you think that you are going to get out of it from an economic standpoint so that you can keep your practice going. And some of it is based on making the right decision because it's the right decision to make. And sometimes it's a combination of both. But in this situation, part of her damages in the civil case were the attorney's fees that she had accumulated, and she testified truthfully. No, I have not paid them yet, but I know I owe them the money. Now, if I decided at a later time to just say, Alvinia, I forgive that debt, that's my decision. Know the rules. Community was important. Going back home for me was a choice. I had an offer of a job in Washington, D.C., or to go back home, and I wrestled with that for a little bit, and then I decided that I wanted to go back home where I had some political roots involved in the community. Clearly, activity-wise, I was all over the place at home when I was in high school and hadn't been back there really since having gone to college. But maintain connections. But the other thing really was I was looking at a lot of stuff that was going on in my own neighborhood, and I'm saying, I can do some stuff about that. I mean, I graduated in 82. In 1985, I ran for, 87. Yeah, one of those years. 85. I ran for town board for the town of Hempstead, the largest township in America. I've said that before. And I lost. And I scratched my head. And then I pulled up one of the books that Denise had given me about voting rights. And I said, how'd I lose? I lost because it's an at-large election. All the votes of the African-American community from Roosevelt, Uniondale, Lakeview, and all those folks were saying, Fred, you're our man. I was saying, thank you very much. Right? And I lost. And then I looked at the numbers, when we looked at the numbers, and sure enough, in those communities, I did real well, if that had just been my district. But there were no districts. So therefore, just like you take a cup of milk and take a spoonful of coffee and put the coffee in the cream and you stir it up, the coffee is completely diluted. You barely even see its effect. That's what was happening to the black vote. So therefore, I looked at it and I said, voting rights. Okay, let me look at this. Okay, Voting Rights Act 1965. I remember that. Okay, yeah. We talked about that. We talked about it in constitutional law. First year, okay, what's the statute? And looked at it, and then all of a sudden I realized, they don't bring that in New York. And then I said, they do now. And we brought that. It was the first real voting rights case brought to that magnitude in the Northeast, and we were successful after 13 years. But the reason I tell you that is because I saw that there was a need, and there really wasn't someone that was going to push the envelope to that effect. There's a little scrawny lawyer from Northeastern who was an upstart, still occupying people's offices. But that was part of the decision that I made, because there was an investment made in me, and I thought it was important to go back. Hi.
How do you find your clients? Do they come to you very much? Are they coming to you?
Yeah. And a matter of fact, most of it is coming from referrals from people in the community that are in the know and know where to send people. And I'll just tell you, we don't just get clients a lot of the cases that we do, nobody ever hears about, because they're not the big issue cases. People that are in need of help. People we do wills, and we'll do some of the stuff that keeps you afloat while you're doing some of this other stuff. We do those as well, and a lot of that comes from referrals in the community. People, as I said, in the churches. It's not unusual for politicians to make that call. Hey, Fred, this is not an official call. And I go, okay, how are you, Councilman? He says, okay, listen, I got this case. This kid got shot in the back. You really need to take a look at it. Can I send them over to talk to you? And they'll do that. But that is another source. Most of it is word of mouth. We don't advertise except for in the journals, where people do journals for the dinners and stuff. Looks like they're going to have something at a country club and they do a journal. We take out ads in all those because it's for the organizations that we think are doing good work in the community, and that's our advertising budget pretty much.
Does your sign outside your office say civil rights attorney?
No. As a matter of fact, you asked a good question. I was in a building, we just moved, we purchased our own building. Okay. We purchased our own building last June. We started construction to rehab the entire building in December, and we moved in June 3rd this year. Our sign hasn't gone up yet because we've ordered it and it's some special casting and something, whatever, and it had to go back and be re-coated and whatever. The building is there. It's just going to say Law Offices of Frederick K. Brewington. That's it. It won't say Civil Rights Lawyer. We're not going to put up a neon sign or anything like that. We do, and I mentioned this in some of the early classes, we do case selection very carefully. And anybody that does this work will say case selection is very important because you can't take every case because you'll burn out as well. We turn down about between 60 to 70% of the cases that come in, and that's all part of evaluation of the cases because there's only so much work that the 8 lawyers can do. I mean, we can't do everyone, and everyone will not be a case that is going to result in the ability to keep the doors open. Some of them will never pay a dime, like Israel Perez, but others will reap a good benefit after the time that you put in. But you've got to make a decision. Case selection is extremely important, and that's a skill to try and evaluate where the damages are going to be and how it's going to come, and if you're going to be able to ever get there. The other support, I would tell her to meet me. We had to go to Queens in Nassau County. It's about a 15-20 minute ride just into the Queens. But for her to pay for car fare every time, so she would meet me at my office and we'd drive to court and I'd drive her back. That was one of the things. And during that time we had a chance to talk, how you doing, other than seeing her in the office. So it allowed us to have that connection. The other thing was the psychological stuff. I mean, she didn't have medical insurance. She did not have the ability to hire a psychologist or a psychiatrist on her own. Her mom was no help. As a matter of fact, her mom was a very bad influence on her in a lot of different ways, not just with regard to the case. And it turned out she had her own problems, but she was just a very bad influence on her from our view. And so what we did was we went into the community and we found a psychologist in the African American community that we told the story to. And I said, would you treat this woman? And I'm not asking you to be an expert, but if you do testify, you may be called to testify, but in this situation she needs assistance and I need to have documentation about what she's suffering. And he agreed to do that. And what he had agreed to do was, in this situation, help her go through a process where she might be able to apply for funds that were available through the state to get him compensated. And he got compensated to some degree. But he joined in on the movement to help Alvenia. He just decided, Dr. James Lassiter, a very good man. And talk about testify, oh, smooth. Oh, man. He was like, and Mr. Brewington recommended her to you. He said, that's absolutely right. And you socialize with Mr. Brewington. He said, well, given the fact that there are very few professionals of African American descent in our community, it is not unusual for me and Mr. Brewington to be in the same place at the same time. If we had more opportunities to have African American professionals, then it was like, yeah, and I'm going like, smooth. I mean, and he came in there and he just did a wonderful job. Yeah.
So, thank you all for coming, and we want to give a token of our gratitude.